Mike, you just did an episode with one of the greats.
Yeah, it was awesome. But man, he dropped a lot of books I need to buy.
Lucky you have a discount code BLWF10 so you can get 10% off.
Welcome to Bad Law, Worst Facts. Today I have on Michael Cowen, who has his own podcast, Trial Lawyer Nation. I'm sure a lot of you guys have heard of it. And more importantly, has the best jersey to have in an office behind him, Johnny Manziel's number 2. Michael, how are you doing today?
I am doing great. How are you doing?
Good, good. And I asked you to come on here because I was actually at your Big Rig boot camp, and to prove to viewers I actually have your mug. I drink out of it. It's a great mug. It's also my firm colors, so I'm a little jealous that you did a better job than my tumblers, but that's okay. But you know, it really was fantastic information, and I really mean that. When I go to, like, no offense to TTLA, no offense to the other CLEs I go to, I'm a little bored, and it's to the point where I'm just trying to get my CLE hours. And going to yours, it was great. And even some of the information that, feel like I have a good understanding on, you still kind of showed it from your point of view, from what you do. It's also pretty cool for you to take an expert live in front of a group of people and show them, how you would do things. So it was fantastic. So I definitely recommend anyone to go if you're hosting it next year. And then I think you're doing something at TOU as well, right?
Yeah, well, we are hosting it next year.
Okay.
It's annual. It's in July of next year. The signups are already available online at bigrigbootkit.com. It's going to be here in San Antonio again. Always try to put on a great event, but now my focus is on my Big Rig Masterclass, which we're going to do with Trial Lawyers University in Las Vegas. The event's October 16th through 21st. The masterclass will be the 17th. So I will speak for a full day on, trying to add value. If you have trucking cases or want to have trucking cases, try to give you something to make your cases worth more money after you leave than they were when you walked in the door. That's my goal, is to provide value for the people that come always. So that's going to be a lot of fun. And plus, we get to hang out in Vegas. That's always fun.
Yeah, it's always fun. I went last year. I'm going this year. It is fantastic. Dan Ambrose, who I've had on the podcast, talks about it. He is a lot higher energy than I am.
Yeah.
So you better be ready.
I love Dan. He's very intense, but I will tell you, I think one of the reasons that TLU is such a great program, well, 2 reasons. One is that Dan pushes his speakers. Most CLE things is like, here's a deadline, turn something in, nobody reviews it, go speak on what you want to speak on. And then if you suck, they might not ask you back unless you're buddies with somebody. Dan, you have to be on multiple Zoom calls. You got to pitch him why, even after he invites you, you have to show why what you do adds value. And then he has multiple speaking tracks at the same time. So you're competing with other speakers for audience. And if you're not providing good content, people can walk out of your room and walk into the room next door. And, it might be a Nick Rowley or Rex Paris or somebody, Joe Freed, some, really incredible person. So you've got to really give the audience something good, or they're not going to listen to you.
You got to bring
It's really, it's a lot harder on us. I mean, frankly,
Right.
I would much rather prepare for something where I'm guaranteed to have the whole room. But
Right.
it's much better for the audience because it means I have to work extra hard when I do something for Dan.
So, I mean, can we peel back the curtain a little bit and ask, what are you going to be teaching in your specific class?
Yeah, I've just got the outline of the agenda, and I'm really looking at giving first the theory and then practical tips on how you can increase the value of your cases. So I'm going to start on the first one's called What the Trucking Industry Doesn't Want You to Know, a systematic approach to uncovering the evidence that will massively increase the value of your trucking cases. So a little marketing spiel in that, the way I wrote the topic, but basically, some stuff's super basic, like why are truck crash cases different than regular cases? Why does that make them increase value? What are the type of things you can find in a trucking case that makes the same injury worth more at both verdict and settlement, because it gets juries mad, which scares insurance companies, how they try to hide that evidence and what you need to do to get the evidence that they're trying to hide from you, and what kind of games they play. I'm also going to talk about some people have heard me talk about this before, but how you create a story that makes the company the villain, and kind of give my theory of story structure, and the jurors need to be the heroes of the story, and what your role is, and what you can do in the case that causes the jurors on their own to say, hey, this trucking company is a problem. They're doing bad things. They're trying to hide what they're doing. They're not telling us the truth. We need to do something about it, because that's something you really want to motivate. Then I've got something that's, more just nuts and bolts. Like here are my top 10 resources. Here are the top 10 things. I know the preventable accident manual is going to be one of them. I used that big time at my last trial. I'm going to try to go beyond just like the Federal Motor Carrier Safety Regulations. Well, that's obvious, but I want to go find, things that we use in our cases that you can use in your case. And a lot of these things are cheap. They're like less than $10, but they add a lot of value. And not just, that, but how to use them, not just give examples and kind of give you the little legal, the words you need to ask an expert or an opposing like corporate rep or safety director to actually get them admissible so you can actually use them in trial. We're going to do some stuff on visual storytelling. We're going to share the kind of visuals that we use in our cases. And then I really want to show my partner, Sonia, does this really well. I'm going to have her either teach me or get up there with me. But she is creating visuals live during depositions. And it's really, really cool. And it is visually engaging on the Zoom. When we play depo clips in trial, it keeps the jury awake. Because if you just have like a talking head for like a 30, 45 minute or worse hour long deposition at trial, I mean, they're gone after 10, 15 minutes. You have to have something that's visually stimulating and interesting. So we're going to talk about that. Something else, again, I'm really wanting to add value to the listener, and it's really fun for the speakers to talk about, this is what I did in this death case, this is what I did in this paraplegia case, and this is like the giant number I got. And frankly, we all want to get those cases, and there's a fear that you get what you speak about, so you don't want to speak about other stuff. But I know most of the cases, even at my firm, and definitely for most of the listeners, are not catastrophic cases. So what can you do in a trucking case where you have a non-catastrophic injury? You don't have a surgery even. How do you maximize value? How do you prove this stuff? How do you prove a trucking company's liable and negligent when you don't have a budget for an expert in the case? How do you get your damages shown in a compelling manner when they're not so obvious? With these invisible injuries, like even a mild TBI or a back injury, a facet injury, something that's not obvious on an MRI or arguable on an MRI.
Right. So the more common cases that most of us have, right, and how to maximize those, that's huge. That's huge.
Yeah, to me, that's and that's, like I said, we all on our websites and our marketing material, we talk about our big wins.
Right.
But I'm luckily at a point now after 29 years. Oh my God, I'm old. After 29 years, that I personally am mostly working on the bigger stuff, and that's more. It's easier, honestly, and more fun. But the fact is, the majority of cases I've had in my career have been non-catastrophic, and I still, will jump in and help out on a non-catastrophic case in the firm, and I still need to coach my lawyers here on how to do that. That's when I'm sorry if I keep rambling on, but a lot of content. I want to talk about some of the tricks and traps that I see defense lawyers doing, both mental games and legal maneuvers to try to pressure us into settling for less than the case is worth and making us think that's all their money there is or there's not, or last-minute stipulations or little things they do to try to put you in a trap. So I want to identify what those are and then give some strategies for avoiding them. Then kind of another kind of nuts and bolts, like, okay, let's say you want to have a trucking practice. You can't do everything yourself. So what are some of and I'll share the actual papers on too, what are some of the forms, what are some of the systems, processes you need to have in your office so that your staff can do this stuff for you? I mean, to automatically send out the preservation letters, to download data off the internet, to send out the preservation requests. Here's a good form set of discovery. It doesn't mean you don't want to add more requests for production interrogatories, but here's something that will work on 85% of the cases. And it's going to give you 85% of the way there on every case. So why don't you start with that? And just kind of talk about, what we do to get cases moving quickly. Because, my goal, we don't always meet it, but my goal is crash to cash in a year. And so, how do you, on a case, if treatment's not a problem, you go from intake to getting the case ready for trial in a year. It's tough, but it can be done.
Very tough. Yeah.
And I want to talk about how you do that. And finally, again, this is a little different, but I want to talk about mindset. I think mindset is everything. And so what I've done, I'm going to talk about some of the times when I've not had such a great mindset and how it's affected me. And then what I've done to create what I call the winning mindset that honestly is one of letting go of the result and focusing on what you're doing, being very mindful, being in the moment. It makes my practice less stressful, more profitable, and honestly more fun. I'm having more fun than I've ever had before, especially in trial. And I want y'all to do that too.
So you convinced me. That by itself, I think is just you should just take over and tell you at that point, because I think those are every single topic is fantastic, and it's something that you have done in your honestly in your boot camp was fantastic. but what you have done just as a person generally. A little background between for the viewers, you and I actually worked on a case.
Yeah.
Yeah, it was a fun one. A couple of years, well, it was about a year ago. And I think I told you this when I was talking to you about it. I was like, look, I think it had been denied by 2 attorneys. And the third attorney, my old boss, I was like, I don't think this is the case. I was like, no, I'm pretty sure. Here's what I'm looking at the rules, blah, blah, blah. Let me ask Michael Cowen. And you were so like helpful. You're like, look, this is how we look at it. This is how we do it. And then I think you and I were right. It was a mid-7-figure settlement. So
it was a nice result. And I'll be honest, some of the lawyers at my firm didn't think it was a good case at first. And, and so it didn't move as quickly as I wanted to at first. And I had to switch it around. But when I dug in, we found a simple on-off switch in that case. Yeah. It's like, if you put a board over a hole in a roof that's 20 something feet above the ground, you have to write hole on it and you have to secure it with screws. And if you don't do that and you leave a loose board and someone falls through, then you're at fault. And there was an OSHA reg on point. It just, when you just say, okay, my client was negligent too, who cares? Let's talk about what you did wrong. It's amazing. Right. But that one we had catastrophic injury. So it was
very catastrophic. Yeah, that's right.
And although the guy had a good recovery.
I was going to say the guy seemed like, and he was not a complainer, right? The client was not a complainer. He just was like, no, I want to go back and live my life. Okay, man. Yeah. Good. It's great.
He was a good guy.
Yeah. So I say all that to say that you have always been the type to just be an open book, which brings me to Big Rig Justice, which is your book. Disclaimer to the viewers. First, buy the book. 100% buy the book. I have it. And I'm going to get paper format. I bought the ebook. It's good because you can read it on planes. It's not good because your book is one of the few books that I actually want to tab up and highlight. You go through and you're like, look, if you have this scenario in an H.E. Mueller case, this is what you need to think about. To the point where a friend of mine sent a picture and he said, I have this picture of this page in a book. I do not know what book it is, but whatever this information is one, fantastic. Two, I need to read the rest of this chapter. Do you know what it is? I looked at it. I was like, oh, that's Michael Cowen's book. Yeah. Awesome. So yeah, I don't ever really get those from, Damages 3 or anything like that, but your book I did. Tell me a little bit about this. I mean, tell the viewers a little bit about the book and kind of what your mindset was in writing it.
Yeah, the book's really it took me 5 years, but that's a little deceptive because I didn't have like 5 years of straight work. I'd work on it for a few weeks and then I would get caught up on doing other stuff and then get back to it. I really wanted to go from, I knew that like I was getting good results in trucking cases, but a lot of what I was doing was kind of intuitive. Like I went to things, I tried things out, things just kind of would occur to me to do them. But then when I was developing a firm, so instead of just me and an associate, now I've got, 10 other lawyers, and I need to teach them to analyze a case the way that I analyze it, because we don't want to lose value in any of our cases. And so I had to go back and think about systematically, what is it I'm intuitively doing? What are the issues that I'm looking for? What is it that makes a good case a better case? What is it that makes a case to begin with? And so I really did a lot of soul searching and analysis and then testing it, and when we got methodical, teaching it to other people, and it was working. And I'd always wanted to write a book. And so I actually pitched trial guides a couple times. Unfortunately for me, actually it's good because I developed more as a lawyer as I went, and it got to be a better book. The first couple times that somebody already had a contract for a trucking book, and they're actually friends of mine, but they never finished it. It's a lot of work to finish a book. And so the contract came open again, and by that time I had the Big Rig Bootcamp. I had a bigger audience. I was speaking more, and so they were a little more interested in me at that point. And so I got the book contract, and so I really wanted to make it, something that you could pick up the book, and your next trucking case would be worth more money. It would be better developed. It would give you tools that would improve your practice.
My favorite thing, and we were talking about this off air, is my favorite thing you say. Whenever I'm like, I know this issue, but let me go consult my book. It's kind of like, let me go consult myself on what I've looked at in the past.
Well, because, when I wrote each chapter, everything was, I did so much work. I would reread everything. I would outline it. I would go look. Right. And, I'm obsessive when I'm writing. And so, you don't always remember all the details of what you wrote 2 or 3 years ago. And so, when I was getting ready to try a case in June where, a tractor trailer stopped in the lane of travel on an interstate highway at night, which is insane to do, but they did. I still went back and read my book chapter again to make sure I wasn't forgetting anything that I knew before. And like, oh yeah, there's that resource out there that I wasn't thinking about using.
Right.
So yeah, it is helpful even for the author. It's helpful to go back and look. And so yeah, I know I've had some other people in the trucking world. It's like, you're giving away all our secrets. Why are you writing that book? But the fact is, there are no secrets out there. We're doing all this stuff in
Right.
trial, and frankly, there's there's several thousand trucking death cases every year. Even if somehow I could get them all, which I'm not going to, I couldn't
Right.
handle them all. And so, do I not want all those other victims to have great representation? Do I not want all the other lawyers out there to be wildly successful? Do I
Right.
not want trucking, values of cases to go up? So frankly, cases can settle for more money and we all do better. I mean, why would I not want to share what I learned?
I 100% agree with you. I also do think that, and this is, myself and other listeners, a lot of times we want to partner with someone just so we have another head to work with, right? Like we have another brain, we have someone in the room. And I think a book like this gives us an idea of at least how you think as someone who does this every single day. And not only that, it gives us an idea of we can get better. So we can get better, we can get better, we can get better. I'm still gonna partner on cases that I think, if I'm gonna have a room full of lawyers, sometimes I just don't want it just to be me. Right.
Yeah.
And so I think the mindset of we're gonna hide things, we're gonna not tell people, that's what the defense does. The only way we as plaintiff attorneys can beat them is we say, look, this is how I did it on this case. You're more than welcome to take a shot at it the same way or change it, make it better. That's how we have, on the plaintiff bar, it's gotten better to the point where the Washington Post is talking badly about us, saying nuclear verdicts. I mean, there's a reason that they weren't saying this type of stuff in the 90s, right? So there's a reason for it. I applaud you for doing it. And go ahead.
Other thing is, there's such a fear, and it's amazing, even among some lawyers who are wildly, not all of them. I mean, if you talk to I'll give Joe Freed and Michael Iserman as examples of people who are incredible about sharing everything and not asking for anything in return and being great teachers and mentors. So I don't want to say it's all, because I have some good friends that have my mentality too, but there are some people that are just scared, like, well, if some other lawyer either asks me for advice or is working on a case with me, and then they learn what I know, then they'll never need me, and then I won't have any business. And that's absolutely false. I mean, what I found is, like, I've had lawyers that I've worked with. We've had some of my co-counsel relationships we've been doing since the late 90s, and we're still working together on cases. But what's happened is they've improved too, and we've learned from each other. And so there are cases that 10 years ago that they would have brought me in on that now they're doing on their own, and I applaud them, I love their success. But the fact is, the cases that they're now bringing me in on are, oh my gosh, I would have never dreamed of having cases like that 10 years ago or 15 years ago. So it ends up working better for both of us. So if you just have this abundance mindset, there's plenty out there for all of us. So, I'm perfectly willing to share. And, if someone comes in and does one case with us and learns a lot and takes that out and then goes and does another 20 cases without us and makes millions and millions of dollars, I'm happy for them.
Yeah.
I'm not saying, oh my gosh, now I could have had some of that money if I just hadn't let them learn no, bullshit. I'm making plenty of I'm making pleny of money. I don't need, I don't need to keep you from making money or handicap you for me to make money. I mean, my gosh, if you asked me, back in the mid to late 90s when I'm starting out, did I ever think I'd make anywhere like 10, 15% of what I'm making now, I would have told you were high. So, I mean, I'm just blessed for what I have. And I want you to have it too. That's the thing. I think that there's plenty out there for all of us.
Talk to me about your most recent verdict.
Okay. My partner, Mallory, and I tried a case, Mallory Peacok, in Dallas. It was an interesting case. I thought it was a very well-deserving case. The defense felt very, very strongly in their position too. It made it really, really easy for us to go to trial. So a tractor-trailer driver was driving. Her story is that her brakes just locked up for no reason, and she was stuck in the middle of 635, couldn't do anything about it. She claimed she had her hazard lights on, and claimed it was too dangerous to put out the triangles because there's too many other vehicles on the road. But plus that she'd only been there for 5 minutes, and she claimed that the regs gave her 10, so she didn't do anything wrong. Our young man, unfortunately, it was hard to see it, but at the same time, he never hit his brakes. He never tried to steer to avoid it. He went underneath the trailer and hit it at about 62 miles an hour. Sorry, about 68 miles an hour. There was a phenomenon called underride, where the vehicle just goes right under the trailer and it instantly killed him. Horrible, horrible thing. The police, of course, blame him 100%. and believe the woman's story. Luckily, the lawyer that brought us in, a great guy named Dak Rashida, he had got a good expert out there and got an inspection done. And what the inspection showed is that she had run over something that pulled out the airline to one of the brakes. We could tell that, one, just because one of the airlines was pulled out and where it fit in, it was sheared in half. It was broken in half, so you can tell something hit it and broke it. And if you looked really close, you could see little contact marks and where the brass was like dented in or scratched. But the other thing is there's a quarter fender right in front of the tire, and that had a big part of that was broken off too. So it was clear that that's what happened. And, our experts said, and he was nice enough to bring us into the case. We worked it together. Our experts said, well, when just the airline just one brake comes out, all the brakes don't immediately lock up. That one brake will lock up. The way air brakes work is if you lose pressure, there's something called a spring brake that activates. It's a safety feature so that one brake will lock up. But it takes, a lot of time for the rest of the air to leak out of the system because you have a compressor running, you have two big storage tanks that goes to all the other brakes. So they, said there's no way that all her brakes locked up. We looked at the physical evidence. There's only a skid mark on one side. If all the brakes locked up, you'd have skid marks on both the right and left side. We only had a skid mark on the right side. And then we got the download. It's funny because it was a download. It was a Mac Anthem tractor unit. So there's not a commercially available download software. So we actually had to go send it. There's like 4 people in the U.S. that can do the download, and we had to send it to one of them. And the defense claimed that the download was a privileged work product and wouldn't give it to us. So we had to have hearings, and eventually, the court orders that we got the download, and the download showed that she actually applied her brakes and that the emergency brakes were not activated. So, we knew that we had someone that was telling a story that wasn't true, which I thought helped a lot. So, we just had to, we did 2 things. One, we talked on the human factor side about why it was so hard for our guy to perceive something unexpected, like a tractor trailer in the road. The other thing we did is she claimed she had the hazard lights on, or the 4-way flashers, is what they call them. But we looked at the police dash cam cameras and as the police were approaching the scene, they weren't on. They came on later, but they weren't on at the time. So that was also pretty good evidence that they weren't on, because within a few minutes after the crash, they weren't on, and she claims that they should have been. So, we had some good stuff there, but they were super confident. We made 3 policy limits demands. There was no offer each time. They just said a reasonably prudent carrier wouldn't pay this, so we're not paying it. It was 100% your person's fault. We didn't do anything wrong. Our driver was in an emergency situation, because what happened when she ran it over and that one brake locked up, it slowed down a little bit, so she's trying to figure out what's going on.
Sure.
But she didn't have to stop in the middle of the road. And honestly, once she stopped, she had 3 to 5 minutes where she could have hit the gas and she still could have gone. It would have taken 5 to 10 minutes before all the air would come out, so all the brakes would lock up. So, we had that thing to go. Now, they had an expert that claimed, well, I think the brakes did lock up. I believe her. So we did testing. We actually got a tractor and trailer, and my experts rigged up a system, and they drove it, and they did a thing that pulled out the airline, and they showed that, after a little bit, one brake would lock up, but it wouldn't stop it. And then they came to a complete stop, and they kept driving around with one brake locked up and showed that they could drive it with no problem. And then they timed how long it took for the air to come out, and the warning light and warning buzzer would come on before, a couple of minutes before all the brakes locked up, which was super important because she testified that the warning light and warning buzzer never came on. So, we had a lot of good things going for us. The defense also made it really easy because they never made any offers before trial. There was a kind of, well, we could probably get you half the policy, $500, if you would take it. And we're like, no. And then right before voir dire, the adjuster came and offered $750, and we said no. And then they never made any other offers during the trial, which honestly kind of shocked me. I thought we were kicking their ass. They would have pitched the limits, but they were pretty confident.
Can I ask, were you able to get the tractor trailer you bought, and you actually did that test? Were you able to get into evidence?
The tractor trailer itself, no, it was a video, and actually our
the video,
they used that. We got it in as a demonstrative, so it didn't go back to the jury, but we were able to show the video to the jury, and we were able to use it in closing.
So what I like about your case is 2 things. One, it is a rear end collision of, I'm sad your client passed away, but it is a rear end collision. That's a very tough case just out the gate. Yeah. And so you just gave me all of these good things for your case, none of which, not one of them, would have been found if you didn't do some digging.
A lot of digging.
A lot. I mean, very deep. Yeah, that's right. And to the point where you bought a vehicle to test this. So I don't know how much more you could do on a case.
This one we actually didn't buy it. The expert rented one, and actually it's a
Okay.
learning lesson from the case. Something that we are doing better now is that we just let the experts do it. They say, yeah, we'll run the test, and we approve the test, and they actually got a different type of truck, model truck.
Okay.
And there's a huge fight, and it was all BS, but they were saying, well, that truck had a different type of transmission, which doesn't affect the brake system. And so that this testing shouldn't come in, and they tried to do some big cross. It didn't go anywhere on it. It was kind of silly, but they tried. And so, we've done some other, we've done testing on 2 other cases since June, or since we did that testing. But yeah, since June, we've done testing on 2 other cases. And in those, it sucks, but I spent the money to actually buy the same make and model vehicle. And what I figure, we're going to buy them, do the testing, let the defense inspect them, then we'll sell them. So, the true expense is only the difference between the purchase price and the sale price. But when some of these trucks are over $100,000. So
They're very expensive. Yeah.
Yeah. But if you've got the right case, it's a good investment.
You're not going to start a trucking company?
I'm not going to start a trucking company. The last one I bought, it was for a conspicuity. It's a case we have actually not too far from you in Brazoria County, where a tractor trailer decides to back across lanes of travel at night to get into a parking space. I'm sorry, to get into a business that's not even open at the time. It's crazy. And of course, our guy couldn't see him in time, and our guy ends up under the trailer. He hit his brakes, but he didn't have time to stop. And one of the issues is that retroreflective tape. It's super visible when the truck is like at a 90-degree angle to you, but when it's at an angle like when you're backing, you really can't see it. But we had to do a demonstration, so then we did a study. So that truck, I wasn't as much worried about how mechanically good it was. So I ended up buying one that was a bit of a lemon. It's got some mechanical problems. It was fine for that testing where we were just testing the reflectivity. But once I get it tuned up, we're actually gonna, just for fun, buy an electronic logging system, and then we're gonna try to show what the company sees on the other end when drivers cheat.
Yeah. That reminds me, at your Big Rig Bootcamp, you did logs and you tested us on whether this person was in compliance or not in compliance. And man, that pissed me off because I was like, I got some of them right, and then some of them I was like, I don't know. And I was like, man, I need to work on this. So I put it on my list of things to work on. So I appreciate that.
Yeah, you need to, because you're a lot of times the experts miss little things too.
Yeah.
Like let's face it, the experts got a ton of cases. They're getting paid by the hour, no matter what you make. And so they do their best. But, when you're getting a piece of the action, you have a little bit more motivation. Also, when you sat in that living room with that family or with that client who's really hurt, our motivation to look harder and spend more time and be more careful is much higher than our experts.
Yeah. Sometimes it's higher than some of our clients, because some of them, for a while, are almost have made peace with it for a little bit. And they're scared, right? Like they're going to have to grudge up all these emotions. So you, during that time period, are working as much as you can, think about it all the time. I call it shouldering the burden of what they're going through, right? But
that's exactly our job. They need to focus on getting their life back as much as they can. And we need to focus on that burden.
So what's also interesting about your case is you actually had a few avenues to go after the digging. You had a few avenues to go, but you tried to make it as simple of a case as possible. What was kind of the focus? Was it just the time period in which this person stopped and then could have got off the road? Because I know there was like visibility issues, there was reflective light issues. Tell me a little bit about that.
Yeah, so I did it progressively. And so the general rule in my case is you don't stop a tractor trailer on the travel lanes of a public roadway, because that's really dangerous. And so we just started off with the reason for the rule. So before I talk about anything in the case and opening, I talk about trucks. You're going to have to know some things to do your jobs in this case. I start off, you have 2 jobs in this case. One, you have to determine whether a trucking company and its employees violated a safety rule and caused a person's death. And 2, if you find that a trucking company broke safety rules and caused someone's death, you have to decide what you're going to do about it. Now, to do those jobs, you're going to have to learn a few things. First, you're going to have to learn some of the ways that tractor trailers are different than regular cars. Another thing you're going to have to learn is a little bit more about one of those ways that they're different. Is that they have something called air brakes. You're just going to have to learn some very basics of what air brakes are, how they work, and what happens if something goes wrong with air brakes. Then you're going to have to learn some of the basic safety rules that trucking companies have to follow, because trucks are different and they have air brakes. And then you have to learn that there's something called a commercial driver's license and what truck drivers must know in order to operate a tractor trailer. So, I get that concept. So we start off with the why. So trucks are bigger, they're heavier, and we wanted to underride, because underrides really important in this case because it's one of the reasons why it's so much more dangerous than even stopping a passenger car on the freeway. And then, then we get into, once we get into why they're more dangerous, and then, we kind of went into air brakes, how air brakes work and what happens if you pull out the line on one and, what you can do about it. We went to the rules. If you have something going wrong with your vehicle, you don't know what it is, the first thing you do is you get off the road. If you can get all the way, off the highway altogether, that's great. But if not, you at least get onto the shoulder. The second thing, even if you're on the shoulder, the second thing you do right away is to put your hazard lights on, because sometimes even when you're on the shoulder, someone gets confused and hits you. And the third thing you do, even though you're parked on the shoulder, even though you're in, you've got your hazard lights on, is you put out 3 reflective triangles, one 100 feet, one 10 feet behind, one 100 feet behind, one 200 feet behind. And because there's no doubt, people get confused with lights, but there's no doubt that a reflective triangle is anything other than a vehicle being stopped ahead. And those are the rules. And so, it's just super simple. And then talked about how the drivers must know these things. Trucking companies drivers must know these things, and to have a commercial driver's license and to drive a truck. And I left it at that for opening, and then called the driver first. And it was a little scary to call the driver first because I knew she was going to say a lot of things that weren't true. And I was a little worried the jury would believe them, but I just given my opening. I was going to call my expert second, one of my experts second, and was going to be able to start disproving things pretty quickly. So I had to trust the jury some. I did cross-examine her on things that I could definitely show with video. She wasn't telling the truth. Like, she claimed the hazard lights were on. I was able to show the dash cam video. It was pre-admitted that they weren't on, and a few things like that. So I had some doubt put in her mind. But when I got her to tell what I call the big whoppers, I would write them down on a giant flip chart and say, and get her to commit. This is what you said. The black box is going to show that the vehicle was slowing down on its own without you doing anything. You were trying to accelerate, it wouldn't. The black box is going to show the transmission wasn't working right. You didn't hit your brakes, it stopped on its own. I got to write those things. And then we went through and disproved them. So, we established what she did wrong first, and then I went into the company, and then went into the company obligation with my trucking expert, went into the company obligations to train, and they said, well, you heard her testify, you were in the courtroom. Was she properly trained? No. Why? Well, because she doesn't know. These are like basic rules, and she doesn't know what she's doing. Well, she had a CDL. Isn't that enough? No. And here's like a government document showing that having a CDL isn't enough. The company has to train, or the regulations saying they have to train. They didn't train her. They had a company handbook. They never gave it to her. So what's the point of having a safety manual if you don't give it to her? What's the point of having safety training if you don't actually give it to your employees? And so the training ended up being a big piss-off factor, but I trusted the jury enough to do progressive disclosure, because if I tried to weave training into the story, it was going to get confusing. And, there's a saying, I don't think I came up with it, but I say it all the time. Lawyers can only win simple cases, but every case is a simple case if you try hard enough, if you work hard enough. You just have to find that one on-off switch, and then you can go from there. And we had other things, like there wasn't proper retroreflective tape on the back of the trailer. A lot of it, about more than half of it was worn out. So my guy didn't get quite the same warning. The triangles weren't there. The 4-way flashers weren't there. We brought all those things up, but those weren't the focus. Those were kind of like extra, like when we talked about, is it fair to blame our poor driver when you didn't give him the triangles? You didn't put on your 4-way flashers. You didn't give him the reflective tape that he was entitled to under the law. I mean, you didn't give him the warning the law required. Why is it fair to blame him? And, we still got they still put 10% on him, but, that's not bad when our guy did. And he was speeding, and he was driving 68 and a 55 and never hit the brakes and never steered. And it was hard to explain why he didn't try to steer at the brakes at the very last second. He definitely, it is what it is. But I think there's maybe a car in front of him that swerved away at the last second. There also were like numerous other people that did not hit it. He was the only one that hit it, and lots of other people avoided the crash. Now they had to swerve at the last second, and we found a person out there that came up on the scene. He almost hit him, but avoided it, and he came in right after our guy, like a few minutes after our guy hit, and was really mad about it. Thinking what she did was super dangerous. So he was a good witness for us. And the other thing we did is there was, our experts roll over. The company had like multiple fines for logbook issues, and this driver had a huge logbook violation in that her electronic logs supposedly weren't working that day, and she wasn't keeping a paper log. But I don't think that we could show that had anything to do with it. Like, it was tempting because it would let us get into the bad safety history of the company, but it had nothing to do with what caused the crash. And I thought it was just added a layer of complexity and confusion, just like some marginal things on her, whether her driving record was good enough. It's just, there's things that, a jury may or may not have believed, may or may not have worked. And I thought that just diminished our case, and just keeping the simple case was the best.
It's definitely you're definitely gonna have a fight on your hands to bring that in anyway, and it may not be worth the juice. So that makes sense. How many days was the trial?
Let me think. So we picked a jury on Wednesday. We started the plaintiff case on Thursday. The judge does not do jury trials on Fridays. We finished the plaintiff's case on Monday, and they did the defense case on Tuesday, and did closing on Wednesday. So 4 full days, including jury selection, but about 2.5 actual trial days. We put on, I'm trying to remember, was it 14, 16 witnesses, some of that in 2 days.
Wow.
Yeah, we're very we really work on refining our best story.
Yeah.
And telling it and sitting down. And so we try to keep, like we had a bunch of people that knew the family. We had a mother and a father of the young man who was killed, and Mallory worked really hard. She had to find, they were divorced, and so she had to tell 2 different damage stories instead of telling the couple's damage stories. But she got people, each person would have a few, stories to tell. She told the jury, you're going to have to, do 2 things. You have to determine what's the value of the relationship they had, and what's the value of the mental suffering that they've gone through and will go through. And so we want to bring you people to talk about those things. And, most of them were, 15 to 20 minute witnesses.
Still 14, 16 witnesses is
that's normal for us. Even, and when we did our product case, we tried it in a week. In a week. I think we have to work really hard on telling the story and telling it clearly and making your points and sitting down, and not trying to make every possible point you can make. Because a jury, if you have a witness more than 30, 45 minutes, they're zoning out anyway.
Yeah, they're lost.
And so, occasionally, like when I've done like a product case and I've had to explain how to design a product and show a bunch of testing. I've had them go more than an hour, but it's a trucking case. It's just not that complicated.
Don't make it more complicated than it needs to be.
You could make it. You could make it. If you read my expert report, he had like a 40-something page report. It sounded very complicated, but by the time we finished prepping him, it became a very simple case.
You actually did a live direct of your expert at trial. At Big Rig Boot Camp, and I thought that was
different
really
expert,
cool.
yeah, but yeah,
different expert. Fair, but you did one kind of show us, and my question for that one is that that was relatively short compared to what I see other attorneys do. Is that kind of how you're doing them for trial as well, or?
It's exactly how we do it in trial. Yeah.
Really?
Yep.
Okay.
Joe Freed came up with the name speed trial. He doesn't like the name speed trial anymore because some people thinks it means you need to go as fast as you can. And I'm not saying Joe didn't get it from me, but we were trying cases pretty efficiently before that. And I'm just a big believer that, simplicity is our friend. You just need to make the case. You need to make your points, but you need to make them simple. And there are cases where you need, people have to learn in chunks. And so they have to learn one concept to learn the next, to learn the next. And there are cases, complex, like if I was going to do I'm not that I do these, but like a pharmaceutical liability. So you have to explain, but even then I try to see if I can get multiple experts to build on each other rather than just one person trying to do it all. But I know sometimes you just have to. So when I've tried like a product case or something like that, you have to have an expert on a little longer because it's a little bit more to put in. But even then you got to break into chapters. But I am just a big believer is find your winning case, tell that story, and stop talking.
Yeah, Jeffrey came up with speed trial. I called Netflix trials. But
there you go.
Yeah, and so the kind of idea is that you're going to have a season. The season is your trial, and every episode has to be 20 minutes to 30 minutes. And that episode has to give you a little piece. So that overall, at the end of it, you've got the season, right? But don't have one episode be so long because people are going to lose. They're going to be so tired of that to move on to the next thing, right?
I think it's more, if you just get your expert report and then you go through and make an outline how you're going to ask your expert everything in the report in the order that's in the report, it will take a few hours.
Yeah.
And the expert will have to keep back and look into the report. And I've even seen like defense lawyers with their people up there, like, and on page this of your report, you wrote this, and the jury doesn't have the report, and they're going to have it. They have no idea they can't follow along. They have no idea what they're talking about. But it's because that's how the lawyer has it. And if you've gone in and looked at like, okay, what is it that the jury needs from this expert? What is it the Court of Appeals needs from this expert? Because I got 2 audiences I'm thinking about. So write those things down and okay, how do I get there? And then practice. And that's something is practicing with the people. And it's a pain to do. You got to make the time to do it, but it makes a difference when you practice with them and give them the confidence. Like, we don't need to talk about all these other things. Like, this is what we're going to talk about. If the other side asks you, you can give your opinion on those other things, but I'm not going to ask you about it because it just, if you, let's say you have 10 ways to win a case,
Right.
and you tell a jury, I'm going to prove that they did these 10 things wrong, any one of which I should win. And the jury's convinced that you proved 8 of those things, but they doubt the other 2. You may lose because in someone's mind, no matter what you told them, you had to prove all 10 because you undertook to prove all 10. Or your damage award is going to be less because you've lost some credibility because you said some things that they didn't believe. Joe, I keep mentioning my buddy Joe. And Joe and I have been friends for over 20 years, and he's got a saying: don't undertake to prove something you don't have to prove. Like, if it's not your burden to prove it, don't take on that obligation. So if, honestly, all we had to prove is it's a really bad idea to stop a tractor trailer in the middle of the interstate when you have a choice, and proving she had a choice. Now, once you made that bad mistake, there were a lot of things that made it worse. But we really brought those more into why it wasn't fair to blame our guy. The on-off switch was, you panicked, you stopped in the middle of the road, you had 5 minutes to do something about it. She was also on the phone, and we brought up the fact she was on the phone, but again, it wasn't a phone case. We just at one point said, she was talking to her supervisor. The supervisor should have said, like, hang up the phone, get on the side of the road, put on your hazard lights, put out your triangles, call the police, and then call me back.
And none of that was done.
None of that was done. And they weren't talking work either. We found out he was actually off work, and they were just chit-chatting.
So she's in the middle of the road just hanging out?
But after when she's on the road, she's panicking. She doesn't know what's going on. I mean, she panics. I mean, she's not like purposely just, her vehicle started doing something weird. She panics, she hits the brakes, and then she stays there. And she's just panicked and says, bring me something out. I don't know what's going on. But she didn't do something like trying, like hitting the gas to move again.
She didn't do anything. That makes sense. And
because she wasn't properly, and the jury got that she wasn't properly trained once they saw that. And maybe I could have put into my opening. We really wanted to do an opening that was under 30 minutes. And it was going to be 20 minutes for liability and 10 minutes for damages. And so I really I had to tell a story that could fit in 20 minutes.
Yeah. Which is, again, Netflix.
Exactly. But you know what? Netflix is compelling. People keep watching. People binge watching Netflix.
Yeah. I spent this week watching Cobra Kai. It just dropped. And if you ask me, it's a terrible story, but I'm 4 seasons in. So I don't know what to tell you.
That's what I'm saying. People binge watch Netflix because it's coming in chunks. But you can walk into any courtroom and see jurors zoned out because they're going on for too long and they're being boring and they're not using visuals that are engaging. And the other thing is people are repetitive. They say the same thing over and over and over again. I mean, the better thing to do is, like, when they say it, write it down on a big flip chart, and then you can go back and refer to it. And, we did say things over, like, is it a good idea to stop a tractor trailer on the travel lane of an interstate highway at night? Everybody agrees that that's a bad idea. I mean, we can get, so we could ask that question to multiple witnesses, but we don't have to like ask our same witness the same thing over and over again. And that's where jurors get annoyed. But that's where I find writing it down. So if you're worried someone didn't get it, what's written down, it's on the flip chart.
Right. It's right here, and it's kind of in their face the entire time for the most part.
And then you can go back and refer and use the same flip chart with other witnesses, because that's what we did so well with the driver. And the best thing is, when they called their crash reconstructionist at the end, and he's the last witness of the trial, and I end with, now she said this, and I put it this. You agree that this is incorrect, and then because I already written my people, I put impossible over it and stuff like that, and so I put trucking companies paid witness agrees, and I wrote incorrect because I didn't want to say that she was lying. I didn't want to use that word. I don't mind if the jury uses that word, but I didn't want to put the word lying in there. But her testimony is incorrect. Her testimony was impossible. Her testimony, and so I'm able to write through her things in red, which her words in red, and have their paid person agree with it. It really hurt their credibility, and it was fun. And my clients were happy. They're like, yes.
What's funny is that at least in your podcast, what I gather is you love crossing experts on the defense. I think that's your number one. If that's what you could do every day, I think you would just wake up and do that.
I once, Alex Begum, who's a good friend. We've been doing cases together forever, and we're actually partners in a New Mexico firm. But Mallory and I had gotten a nice verdict in a case, and they had a particular defense expert in that case, and it was one of the best crosses in my career. And the same guy was testifying on one of Alex's trials in Brownsville, Texas, the next week. And Alex says, "You want to come in and cross him?" I said, "Yeah, I'll do it." And so, I filed the defense lawyer went nuts. I filed my notice of appearance at 4 a.m. I went down to Brownsville, Texas. walk into the courtroom, the defense lawyer trying to say that I couldn't do it because I hadn't been there for the rest of the trial. And the judge is like, if they want to let a new trial lawyer come in, I'll let them do it. I mean, and, I went and I had a great cross, and then I left and let Alex do the rest of the trial. It was so fun. I don't know that that's the best thing for jury relationships or whatever, but I mean, I loved it. And he got a verdict, and I just said, pay me what you want. And he sent me a little check, and it was, it was all good. But yeah, it was just so fun because I didn't have all the work. I just did one witness and came in, came out, and it was a joy to do. But yeah, that's my favorite part of trials is cross, even more than, I would say cross, then somewhere between opening and voir dire.
Okay.
I used to say earlier in my career, I would have said it was closing. I'm less convinced that we have the power to persuade and change anything at that point. It's not as fun for me, and I still like it. I still like giving a good closing, but I would much rather be doing a cross because that's where I feel like I'm totally in control.
I tell people closing is more of a kind of the end of the marathon, right? So you either kind of know what place you're in, or you're so at the far back you have no clue. At that point, you just got to finish it and go have some water. But
it's about arming your soldiers that are going to go and fight for you. It's about giving them what they need to do, clearly explaining what their job is. Yeah. But I don't know how much we really persuade people. I think we can sometimes up the number a little bit, but I don't think on the winning or losing or whether our client's hurt or not. I don't think we change their mind in closing after they've heard all the evidence.
It's crazy. Every time I talk to you, I know that you're such an avid reader because every concept you bring, it's like you've made a mix of a lot of the concepts that are out there and made it your own, and it's really starting to work for you. I mean, I'm not saying it hasn't worked, it has, but like it kind of shines out that you've kind of created this from everything. I mean, there's not one person out there there's people out there who say, I follow this model or I follow that model, but you have kind of intertwined everything that from, for example, every guest that I've had, like even Mitnick stuff, Sarah Delamont stuff, and obviously the reptiles theory, obviously David Ball, and made it your own and done it in a concise manner and done it in a way that you can actually repeat it throughout your law firm and teach it to associates. So that's extremely a lot of work, but extremely impressive.
What it's taken is studying the other people's method, trying the other people's method, seeing what aspects work and what don't work as well for me, and what, like, starting with a rule. Like, lots of people say to start with a rule. I mean, David Ball, Rules of the Road, and it works for a lot of people. To me, it feels preachy, and it's just to me. Now, I did start with a rule in my product case I tried, which is, if a company knows that they have a problem with their product that's hurting people, they need to fix it or something. I don't remember the exact. I had a much better. No, a minor mistake shouldn't lead to catastrophic consequences or something, whatever it was. But it's something I got from the jury in voir dire, right? And I used words that the jurors they agreed with. We all agreed on it. So it wasn't just coming from me. But I just feel like if I go in there, like a truck driver must stop, put out their triangles within 10 minutes, or else they're negligent. Like, who am I to say that when I start? I just, and maybe it's just a me thing. And so I'm not telling people not to start with a rule, but to me, I'm like, is there a better way to do this? And to me, if I'm trying to get the jurors to engage, to be heroes, to be thinking about what their job is, I'm trying to talk to them about what they're going to have to do, what their job's going to be in the case. That's just me.
You still intertwine Rules of the Road, right? I mean, you still.
Oh no, absolutely. We use rules and we make them super clear. And Rick, I love Rick Friedman. He's great. Yeah.
So I think what I'm saying is that you've intertwined it. So you've essentially taken, like, the hostage to hero is what you're referring to. Sorry, Delamont's book, and said, look, they're a hostage right now. I cannot preach to them. I cannot tell them. I can't do that. I've got to say, you are the ones who are going to be. I'm going to give you ammo to determine what the outcome is. And then along the way, as you've built that, you've started doing rules, you've started layering this stuff. It's like I said, your boot camp is fantastic because I think you have gone out, you have read way too much, and built it and made it your own in your own way. And you were saying, hey guys, here's what I have done, and here's what I go and do. Yeah. You've got to find your own kind of flavor or recipe, but here are kind of the nuts and bolts to get there.
I do encourage people to work. Like, I've done a lot of work with Sarah. I haven't just read her book. I've done a lot of work with her. In fact, you can see some pictures of me in her book as modeling hand gestures if you look, because I was working with her. It's just random. I happened to be working with her the day they had a photographer there to take book pictures, and I said, yeah, I'll be in there. A little heavier there than I am now, so it's a little embarrassing. But but the thing is, I think it really helps to go to the Jerry Spence Trial Institute or the Trial Lawyers College. Go work work with David Ball in a case, go work with
Yeah.
Sorry, and go in when you go work with them. Don't go say, well, I don't know about this. Go in with an open mind and like do it their way when you're there with
Yeah.
them. And then when you're going to go try the case, see if that feels right or not. But if you don't like open your mind and try to learn their way, you don't know if their way is really going to fit for you or not. And so, I've spent a lot of time and money working with as many people as I can work with. And, and I do. I think I've finally been able to mix it. And part of it's a confidence too. Like, so I used to think like,
Right.
well, I'm going to do a David Ball or a David Ball opening, or I'm going to do a reptile this, and then I think it took a little more than 20 years of trying cases to finally said, I'm just going to be me. And so I've learned a lot of things. I'm going to do what works for me. You can't get there until you learn other people's methods and you try them. And frankly, you just need to go in there and try some cases.
Yeah, no, absolutely. And it's like, I put it akin to boxing. So, you can have your own method of boxing, but the only way you can have your own method of boxing is if you train other
Yeah.
people's method, and a lot of them are basic, some of them are more complex, and you train other people, master that, then you can say, okay, how I react to certain things is how I do this. Same thing with how you are as an attorney. Like I said, for you, if you're going to start with the rule out the gate, you may not be the most trustworthy person coming off. But if you arm them and then you start putting the rules and you start layering it, and the way you layer it is fantastic, by the way. I mean, it really is. You're like peppering it in as you go. And it's not boring. I mean, like we said before, 14, 16 witnesses in that amount of time is absurd. It's very quick. It's very direct. It keeps people focused. And on top of that, you're still peppering in rules. This is what we're doing.
Yeah.
It's clean. But you cannot get there without reading the books, doing them, practicing it, and going there with exactly not only an open mind, but ready to do it their way. But
I think the other
yeah.
secret of trying cases quickly is visual.
Yeah.
The more visuals you have, and sometimes the visuals are words, but I mean, the more things you have up there, the easier it is to explain things without things that verbally you would have to really, really explain for a long time. You can show visually very, very quickly.
So I'm doing a thing now where I am doing, and I think you brought it on off air, but about doing, your exhibits basically live during a deposition.
Yeah.
I don't think I'm that good. I've done it a few times, but I will have prepped exhibits that I'm asking yes or no questions, and I'm trying to intertwine that to my voir dire, then into my trial, kind of like Edkin did in that verdict a couple years ago. And it's because you're right. No one likes to hear when we're talking, we're doing stuff. No one's going to listen over a long period of time unless you're super interested. And most juries are not super interested at the get-go. Yeah. But if you're adding visuals, you're doing the stuff. And the cool thing about what we do is that a lot of it has to do with like high speeds and things happening. So you can really intertwine a lot of stuff and make people interested. But if you stick to a boring case, that's what it's going to be, a boring case. You're not going to get a good verdict that way. So visuals are huge.
And you don't have to hire one of these companies and I mean, there are cases that justify that, but there's a lot of things you can do on your own just with PowerPoint, honestly, and just stock images that you can go get for like 99 cents an image online. I think it's 123RF. There's one that I learned from Mark Lanier. There's deposit photos. There's Shutterstock. The AI ones always make weird things and never make exact. I don't know how to prompt them right, so I don't end up using many of those. But sometimes sometimes it's an image from the case, and then sometimes it's just Google Earth, and then you put in PowerPoint, I just put like a truck or a rectangle to square to symbolize a truck, and then move them on the Google Earth image to show what happened. I mean, it doesn't have to be something super expensive and high tech, but it still needs to be interesting and clear and simple, and test your visuals. And, do your visuals actually show what you think they show? Because we spend a lot of money on animations, and when we've tested them, sometimes it's like, wow, that truck driver didn't have a whole lot of time to avoid this. Like, that's not what we wanted to show.
It's funny you mentioned that. And it's, short, and then we'll close. But I went to Lanier's thing, and then he said, get the IPVO, do things, draw it. So Lanier's thing Friday, trial that Monday. That I got called over the weekend to go try. Terrible case. I'm like, I'm gonna try this. I got the IPVO. Let's go do this. So Sunday, I'm like, I'm gonna practice drawing it. I'm like drawing this thing. I'd look like a serial killer with the drawings. So then I was like, all right, I'll write it out. So I'm like writing out questions, like answer this question, blah, with the IPVO. And I realized, I guess I'm like stressed out during trial or something. I'm drawing it. And I'm like, this looks like a toddler did this. So I realized drawing is not my forte. So I'm trying to do it other ways. So I do have what you're saying. I do like take clips from things and then kind of use it visually, because I could do that, but Drawing is not my forte. And I learned that live during trial. So that's great.
I learned I needed reading glasses live during trial. I was cross-examining a defendant driver, and he had my outline, which was printed in bigger point. And if he says this, I had like the page and line the depot to impeach him. And so I pull out my transcript. Isn't true in your depot you said, and I had to go, Mallory, what did he say? And I read it for me because I couldn't read. I couldn't see I couldn't read the writing. That's when I first discovered that I'm getting old and need reading glasses. I've had, if you try enough cases, things will go wrong. We had a case, one of my first solo jury trial, my boss had a high school physics teacher as our expert. And one of the big issues in the case is whether a store should have had laminated glass instead of plate glass, because the laminated glass would have broken differently, and the plate and the laminated glass was stronger and the plate glass breaks more easily. So he had done like a videotape demonstration, but he didn't print it to other sides. So we couldn't use the videotape at trial. So we just had the expert with a piece of laminated glass and a plate glass and a hammer in the courtroom. And we're going to show how much easier. He could not get, it took like 40 or 50 blows and more than 5 minutes to break the plate glass. It would not break with the hammer right in front of the jury. And then of course the laminated glass broke just like that. Not laminated, tempered glass. It just, I know this was 1998, or 97. I'm still traumatized by it. And of course we got a zero verdict. Now there's a zero offer too. I mean, there's a reason that they sent the 2-year lawyer to go try the case on his own with solo. But
with just 2 pieces of glass, said good luck.
Yeah, but it just shows you things do go wrong in the courtroom, but other times things have gone wrong, and we've done just fine. I mean, there's no trial is going to go perfect.
No, not at all. Michael, thank you so much for coming on. I'm going to put a link to the TLU. I'm going to put a link to your book. Last few trial guys is actually giving me a discount code. I'll see if they'll do it this time. No promises. But if they do, I'll get a discount code as well too. Anything else that you can think of?
No, if you see me speaking at anything, I'm always happy to talk to people. Anytime you have a question on a case, it doesn't have to be for a referral. I mean, if I have time that week, I'll make time for you. So just, send an email to michael@cowanlaw.com. I believe that the better we all do, the better we each do, if that makes any sense. So I want everyone to succeed and be happy and have a great practice.
I appreciate it. Oh, last thing, November, A&M or UT, who you think is going to take it home?
Ags, 100%.
Yeah, 100%.
And I'm going to be there yelling my heart out.
Right, we've had a lot more upsets in the past, so I think they're undervaluing us this year. But anyways,
absolutely, I believe in Elko.
That's right, I do too. All right, well, you take care of yourself, and thank you so much for being on.
Okay, thanks.